if the person you are referring to in 25.3 is suitably qualified, so we're turning it around. If that person is suitably qualified, then their appointment cannot amount to gratification.
Correct.
You accept that?
I accept that.
So if we accept that Ms. Mukwele met the requirements that we put up, then her appointment cannot be gratification at that level only.
Absolutely.
Yes.
And if you'd allow me to maybe finish the thought is, as I've indicated, I would have to go back into those matters that are still under investigation and to determine whether or not those aspects raised are then still relevant. Do they find relevance? Because if, in the manner in which we have engaged, if those aspects no longer find relevance in those matters would have to be closed and dispensed with.
Because for one to get to the point where one says their appointment amounts to gratification, one must start at, did they qualify for the position?
We have to start where
Because
you started.
if they qualified, then they were properly appointed, and their appointment cannot amount to gratification.
That is correct. Yes. And so both, sorry, Council. Sorry. And so both the vetting processes, those allegations of the vetting processes, as well as the allegations of the recruitment and gratification for the matters still under investigation, have to be properly revisited.
I think the vetting issue in respect of Ms. Mukwele, we can put that to bed because Colonel Padiaki accepted that the way CI did it, the way the panel did it, disadvantaged Ms. Mukwele. It did not benefit her because the requirement said she must subject herself to vetting 6 months after the appointment. So the fact that they were doing it before the interview was in fact disadvantaging her, not benefiting her. I think with Colonel Padiaki, we settled on that and he accepted.
Yes, I accept that. I'm saying with all other, the averment of persons not suitably qualified and or experienced, and or with regards the vetting, if they still find place in those other investigations not yet completed, those would have to be looked at as a matter of urgency and dealt with.
I don't want to force you to concede that because the other people, the process of their vetting was different.
Yes.
With Brigadier Mukwele, the requirements were clear that it must happen 6 months, within 6 months after. So the other people that you referred to in your summons, I'm not there yet, so I don't want to force you to concede that just yet.
Thank you, Commissioner. It's not a concession. It is a matter of saying, I have heard the argument and I should reapply my mind, given all of the discussions that were raised.
Your response to Commissioner Khumalo that if a candidate meets the requirement, then there couldn't be gratification. I don't know that that is correct in your present case, that kind of answer, because gratification is a quid for a quo.
Yes.
So the way you have constructed the charges against Ms. Mukwele is that she was given the position so that she can do something. So she's been rewarded with a position to do something. And that's something you have described it as capture of crime intelligence. You have described it as such. So it seems to me that on the case that you have, it really doesn't matter whether she met the requirements or not. Your case is, this is a precca offense. They have appointed this person so that they can siphon off funds. That's Mr. Adams's complaint, which you have agreed with in the formulation of the charge. So and I don't expect you to do the same thing that Colonel Padiaki did, which is, well, we don't know what the offense in the future will, whether she will commit it or not. But the charge itself would have required you at day one to say, and maybe you do have that. I'm not getting into the merits of whether you have a winnable case or not. I'm speaking at the starting point is you formulate a charge, and if the charge is giving someone employment, that's one form of gratification. It's employment in return for something. That provision in PRECA doesn't say someone who's not qualified.
Correct.
It doesn't. So she may well be qualified, and yet she gets appointed precisely so that she can assist to achieve certain ends. So your concession that you are easily making now, that, well, if it is a qualifying person, there could not be an offense of gratification. The offense is not just the appointment.
Yes.
The offense is you get appointed because you're going to give something
Yes.
in return. So your answer, you have to amend
Yes.
your answer to Commissioner Khumalo.
The answer talks to the suitability in terms of the appointments and whether or not the vetting processes were met. The additional issue, if in fact related to all and not just to Mokwele, would have to be looked at differently. The appointments of persons not suitably qualified and or experienced as a form of gratification for their collusion later on. I have to see what that investigation says. I cannot tell you that there is in fact evidence that there is collusion. The concession I make is that with regards to suitability, the standing instructions, and the vetting process, those are the matters that I would look at. And
No, I'm not raising with you, certainly not raising the vetting issue. I'm raising a narrow issue with you, which is your answer, your concession to Commissioner Khumalo suggests that you accept that because if it is found that she met the requirements, then we were wrong to claim gratification, that this is a PRECA offense, which is a gratification offense. I don't remember the exact wording of that provision. I'm saying your answer to the extent that you're saying, well, if she did meet the requirements, then we are wrong. I'm paraphrasing. I'm not saying that's what you said. If your answer is because she meets the requirements, or if it is found that she met the requirements, then we couldn't speak of gratification. I'm saying you are wrong because
Yes.
that's not what that offense is about. That offense is you will prove in court that her appointment, it so happened that you say she's not qualified, and you say she's appointed even though she's not qualified. But in court, you will show that this appointment, qualified or not qualified,
notwithstanding is a gratification.
it's a gratification for what she's going to do. You understand the point
Yes.
I'm making?
No,
You
that
agree with
does
my,
not fall away.
You agree with my construction?
I agree with your construction. That is not that's not a concession. It is to look at the suitability in terms of the advert, the requirements, the standing orders.
Okay, thank you.
If there are, in terms of the other investigations, and I'm not saying there are, in terms of the other investigations, I need to go and check.
Okay, thank you.
I do need to go and check.
Thank you, Mr.
Careful, I was limiting myself only to your paragraph 25.3.
Yes.
I was not going to the offense in section 3 of PRECA, which is what Commissioner Baloyi is engaging you on.
Yes.
So the answers to both our questions may be different.
I understand, and I didn't assume
Yes.
that you went beyond
Yes,
just the
I deliberately
suitability.
avoided going to the charges. I was just sticking to your statement.
Yes,
Okay.
I accept that.
Thank you, Commissioners, and thank you, Advocate Johnson. For my edification, 25.3, does it apply to Mrs. Mokwele? Or do you think it could potentially exclude her because she might be suitably qualified? How do I read it? How do you suggest I read it?
So we have agreed, Council, that she is suitably qualified.
So therefore, the remainder of 25.3 doesn't apply to her?
She's suitably qualified and experienced. The appointment of persons not suitably qualified and or experienced as a form of gratification for that doesn't exclude that part of why she was appointed, even though she's suitably qualified. Yes.
So then, she is not out of the woods yet, because if you are to concede that she could potentially be suitably qualified and experienced, her appointment in and of itself is gratification for her collusion later in the looting of state funds.
That is correct, yes.
What in the investigation leads you to believe that in the future she will collude in the looting of state funds? Something in that investigation must have pointed you out to this. What could it potentially be?
So the information that we had at the time was that in the process, she would have been part of a process where monies would have been taken from the secret funds in order to purchase properties, and that her placement there would have assisted that process. That was the contention or the allegation.
As a mechatronics, whatever,
No,
I'm trying to understand. I hear what you are saying is restating what is contained in 25.3. You're
Yes.
not giving me a basis for that conclusion. You're already concluding that she will be involved by virtue of occupying that position. And I want to understand what in the investigation leads you, by you I mean IDEC, to conclude that you give her that job, she's in the Secret Service Fund, and therefore she will be looting state funds to pay. She'll be colluding, I correct myself, I don't know with who with, but to loot state funds and purchase properties. What in those files should we look out for to support the conclusion that you draw, the fear that you express at 25.3?
I'll just have to be given an opportunity to go back and to look into the evidence.
No, you
That
must have
relates.
had it. For you to submit on oath, you confirmed
Yes.
the correctness of this statement when we started. So
Correct.
you must have an idea, and I suggest that perhaps you start sharing it with us. Might not be firmed up. When you return, you will give us the full now facts, chapter and verse. But for now, when you wrote 25.3 in relation specifically to Mrs. Mukwele, on what basis did you conclude that she was going to collude in the looting of state funds with whomsoever?
Commissioners, I ask for a moment.
Yes, please.
Are you thinking of a specific document, perhaps?
I'm just perusing.
I'm not.
Sorry,
I'm not.
Commissioners.
I'm not rushing you, but,
Yes, I'm trying to peruse through the charge sheet to at least refresh
oh,
my memory.
okay, please go ahead.
Okay.
I think the commissioners were giving you an opportunity. Have you located what you're looking for?
It triggers, it triggers the recollection. And I'm going to hold you to, I'll have to come back with the chapter and verse.
Okay.
I recall that when it came to where she was positioned in TSS, TSS is a covert environment with a very big budget. And the allegation was that if monies were needed, as an example for the purchase of properties, monies would be able to come out of there. And that if she was asked, because of disappointment, she would have felt the need to act. That was the projection, and that was the understanding of where.
Sorry, as to do what exactly?
Sorry. If the understanding of where.
Sorry, as to do what exactly?
Sorry. If monies are required or needed, the technical support services to which she would have been appointed has a very big budget. It is a covert environment. And I think the manner, and I'm giving you the explanation as I understand it, the manner in which funds are dealt with are not as open source as everything else. And so should the need arise for funds to be procured, that would be the environment from which funds could be accessed, for example, for the purchase of properties. That is how I recall.
Unlawfully.
That is correct.
So she would violate her duty of good faith to her employer. She would breach her contract of employment.
I think the contention, Commissioner Khumalo, if I recall correctly, was because the monies are in that environment, she could be approached to make those monies available. I don't know what would be presented to her for her to make those monies available, but that is where the funds are for her to make available.
But if she's doing that as part of her job, how does that rise to gratification and unlawful conduct? Because what you are saying, that would apply to any person who occupies that role.
Correct.
If they are required to provide money, provided that they are complying with the prescripts and they are doing that correctly, that's not a criminal offense.
No, it
They are
isn't.
simply doing their job.
Yes. If she was approached for access of the TSS funds, knowing that whatever that motivation was, she should not approve that funding.
Yes, but how
That
do you
is-
how do you leap to the conclusion that she would loot state funds? Because that's what your 25.3 says. If she's approving a request and she's doing it in accordance with the prescripts, there's nothing wrong with that.
Not if she's doing it in accordance with
Yes.
the prescripts.
So what is the basis of your assumption that she would have done it in an unlawful manner?
That she would have been approached to make monies available under circumstances where she would not have made them available.
But how do you know that?
That was because of that environment and because of the fact that from previous matters, not in IDEC, that is how funds were looted. Out of accounts where the funds are within a covert environment. So motivations would be put in for access of that money.
You are being,
Without-
if I may come
sorry.
in, no. You are being grossly unfair to Mrs. Mukwele. Now you are attributing conduct of persons she has no knowledge of to her in the future, no how. And you are saying you accept that she may be required to access those funds in the course of execution of her job. But the impression you create here at this 25.3 is that she would do so to loot. So that apology that I think you sought to extend to her, you might as well take it back. You are seriously impugning her credibility, and we're trying to find the basis on which you say she was going to loot.
I hear you. That is not the intention. I'm trying to give an example of how I find that space. Of how I find that space. And,
You see,
sorry, if I...
Oh, no, you may
No,
continue if you're not
No,
done.
I think it is...
You might as well take it back. You are seriously impugning her credibility, and we're trying to find the basis on which you say she was going to loot.
I hear you. That is not the intention. I'm trying to give an example of how I find that space. Of how I find that space. And,
You see,
sorry, if I...
Oh, no, you may
No,
continue if you're not
No,
done.
I think
Yeah.
it is also wholly unfair. There's no intention to impede on her dignity. I am merely expressing or amplifying on the question. If that is how it comes out, Council, really, it is unfortunate that you think that I would, in giving an explanation, that I am intentionally impeding on her reputation and her credibility. I do apologize if that is how it comes out, but, and to say that my apology, in fairness, Commissioners, that I made earlier, I will not willy-nilly make an apology. The Commissioners did not drag The Commissioners did not drag an apology out of me. I made that apology freely, and I think it should be taken from where it came. It did come freely.
You see, if there were substance in what you are saying, it would apply across the board. That is to anybody appointed to that position.
Correct.
That must be correct.
Yes.
Yeah, because you have no basis to think that she is different, and that therefore this would apply only to her. So anybody,
In that position.
if what you say is logical, anybody would also be susceptible to this impropriety.
I accept that, Chair.
Thank you.
Advocate Johnson, in June 2025, this is exactly the charge that was presented, even in the draft charge sheet to justify Ms. Mukwele's arrest. It's exactly this. So she has gone through all of this over a period of a year. It's not new that for the first time today you are making this allegation. The memos, the draft charge sheet, and all the documents, this was exactly the issue. And I say this for my part, I have no sympathy for people who loot state funds. And if there are people, whether they are generals or not, who are involved in the looting of the secret account or whatever it is, I have zero sympathy for them. But this case, as Commissioner Baloyi said yesterday, is a serious abuse of power by IDEC to target a civilian. And that's what I have a problem with. My sympathy for her is a bit different to the generals, because if they did what they did, the law must take its course. But we must draw the line where organs that are supposed to protect the public and, you know, work for the benefit of the public are used in this manner to unfairly target civilians. That is just not right.
I understand, hence I made the apology earlier.
Yeah.
It does not detract from the fact that there is a case for which they have now made representations, Memokwele
And
as well.
you said, it's not just the representations, there's also the review process.
Exactly,
that you referred to.
and yes, and so in the end, fairness and justice must prevail. So if we have made the wrong decision, then that decision will be corrected. And I'm saying that in terms of the appointment, I'm not retracting anything that I said at all.
I think my difficulty with you is if you should not think that the fact that there's a review process, there's a representation process, and therefore what you sought to do, which is to prosecute, if those decisions are reversed, then all is good. It cannot be that. Our inquiry is really about why did you make these decisions? It's not about the merits of your case. And I think we may not have fully succeeded to steer from talking to the merits because they're intertwined with your processes, your thought processes, your decision-making process, what you evaluated, and we compare that with the legislative mandate that you have and requirements. So fact that there will be reviews and representations that maybe do succeed is not really of our concern. Our concern is how do you make this charge, for example, how does that allegation even arise that she is potentially guilty of a PRECA offense of gratification, but not just her. And she has been the focus of Commissioner Khumalo because she's a civilian. But any criticism that comes out of Section 25.3, in my view, applies to everyone that you have charged with an offense of gratification as defined in PRECA. And it comes from, but there are no facts alleged by Mr. Adams, the aunt, not in his Section 27, not in the affidavit, that paragraph 2 that speaks only about Ms. Mokwele's appointment. Nowhere else does he make allegations that form a reasonable basis for you to prefer a charge of gratification as defined in PRECA. That is really the issue, right? And so the inquiry to you is, why did you authorize that? Why did your investigators get to that point? Why did the prosecutor, firstly your internal prosecutor, get to that point? Why did your DPP, who said, I concur with the charges, they are good, what were they working off? So we're still at first base, before representations and before a review. Where does this all come from, right? And on the face of it, so far, between you and Colonel Pareachi, you haven't given a satisfactory explanation, I must say. And I accept that you're still going to give us documents, the statement, the A1 statements, and maybe we'll see from there what were the facts that led to this allegation in 25.3, but also that led to the charge itself. Absent that, if you do not have documents that show the facts on which this charge or this 25.3 is founded, if you don't have any such documents, then this was an arbitrary decision not based on any facts, and because of it being an arbitrary decision, it is a use of investigative powers for ulterior purposes, if it is not explained satisfactorily for ulterior purposes, then we have to ask the question, what was the purpose? I hope you understand,
I do understand.
what I'm saying, yeah. So we still have to answer that question.
Correct.
And hopefully your statements will the A1 statements will put us at peace that, well, there was a basis for that. But as matters stand, I must say, from where I'm sitting, that with everything that is before us, and until we get something else, then the exercise of the power to investigate and to charge an offense of gratification under PRECA was exercised without proper consideration, without facts placed properly, and I underline properly, placed before you for this, and the prosecutor and all the people that I've listed, to formulate that charge. On the face of it, the power that you have, all of you that I've listed, you exercise it for an ulterior purpose, and hopefully by the end of the evidence of the IDEC witnesses, we will find out what was the purpose. That, for me, is the real issue here. Do you have anything to say to that? Thank you. Thank you, Mr.
Thank you.